We have finished the law of indemnity, and last time I was just discussing about the law of guarantee. It is laid down from section 127 to 147, that is 20 sections are there. Here, as far as the law of guarantee is concerned, it is defined as where a third person offers to perform the obligations or pay the debt of another person called the principal debtor. In case the principal debtor does not pay, the guarantor or the person who offers to pay the money or perform the obligation is called the guarantor, and the person to whom the guarantee is given is called the creditor, and the person to whom for whom this guarantee is given is called the principal debtor. So it is something like what is called the guarantee is some third party who is interested in the principal debtor and has nothing to do with the money transaction, says that in case of default committed by the principal debtor, I shall pay the money or I shall perform the obligation which remains unfulfilled on the part of the principal debtor, and this in law is what is called the contract of guarantee. Then that is a guarantee agreement is a contract action from it is said that there are two parties. One agrees to pay a debt or perform an obligation in the event of the original party failing to do so. It is sometimes called a guarantee or a warranty. Why is it called a warranty, sir? Warranty is by that guarantee furnished, a warranty is given, don't bother Mr. Creditor, your money is not going to go anywhere. In case the debtor does not pay, I undertake the responsibility of paying the money and I stand guarantee, I stand as surety, and the warranty is given, don't bother about the recovery of the money or performance of the obligation. That is the reason sometimes guarantee is also called a warranty, whereby an undertaking is given to pay the debt in case of failure on the part of the debtor to make the payment, and this is what is called the contract of guarantee. Then the first one is nature and scope. Scope is events and circumstances, representation and warranties, covenants, subordination, certain indebtedness. So for a contract of guarantee to arise, there must be what is called there must be a debt, there must be a debt which has to be paid, and the third party offers to pay the debt or perform the obligation in case the principal debtor does not pay, and this is the nature and scope of the contract of guarantee. As far as the model form for agreement of guarantee is, you can draft it in any form you like, but the model form I could tell you is this agreement of guarantee executed at Hyderabad on this dash day of September 2024 by Mr. A, son of so and so, age so and so, occupation so and so, and resident of so and so, hereinafter called the guarantor. Then in the middle you say in favor of the creditor, whomsoever the creditor is. The State Bank of India, having its head office at Bank Street, Hyderabad, and one of its branches at Patti Circle, Secunderabad, represented by its chief manager, hereinafter called the creditor. Then next para is whereas whereas Messrs. A and Company has availed of loan facilities from the creditor under the bill discounting, cash credit mandi type, and working capital arrangements, and the creditor has advanced the amounts to the principal debtor in pursuance of the request made by him. Next part. Whereas the creditor has requested the debtor to furnish security of some person who will undertake the responsibility of paying the money in case of any default or in case of non-performance of the obligation. Next one. Whereas at the request of the creditor and the principal debtor, the guarantor hereby undertakes to offer his guarantee for recovery of the amounts sanctioned and paid to the principal debtor, or in case of non-performance of any contractual duty, he undertakes to perform those contractual duties and then clear the indebtedness as far as the debtor is concerned. Then next paragraph. Whereas the guarantor, without any compulsion or force, has agreed to stand surety for not only the present, past and future indebtedness of the principal debtor, and shall make himself liable to pay the money to the creditor in case of any indebtedness on the part of the principal debtor. Now this agreement of guarantee witnesseth as follows. 1. That the guarantor hereby agrees that the loan facilities has been granted by the creditor to the principal debtor so and so, and to the tune of so and so towards so and so facility on so and so date, and primary documents are obtained from the debtor. Number 2. At the request of the creditor and the principal debtor, the guarantor has undertaken to furnish this guarantee on the understanding that in case of default on the part of the debtor to make the payment or non-performance of the contractual obligations, the guarantor shall make himself liable to clear all the outstanding present, past and future transactions. And then the question is, the guarantor undertakes and guarantees payment and performance of the obligations on behalf of the principal debtor. The guarantor irrevocably, absolutely and unconditionally guarantees the lender, his or his successor, the payment or performance of the guarantee amount or obligations. So there is an unconditional, absolute and what is called undertaking or acknowledgement to clear the debts or to perform the contractual duty on the part of the principal debtor, and the guarantor says, in case of default, I shall perform the obligations. Then it is also said here the guarantee agreement cannot be revoked and obligations not reduced, not relieved. So the question is, as long as the guarantee remains, it is an absolute guarantee, and the guarantor is liable till the entire debt is completely wiped out. And sometimes the guarantor may also agree that he shall waive the notice and payment of subject to the payment of all expenses to the lender, and also that no notice to pursue dues. The guarantor will not approach any third party to see that the debts are paid. There is an unconditional undertaking on his part to clear the dues in case of default on the part of the debtor, and in case of bankruptcy or insolvency of the debtor, the liability of the guarantor will remain till such time the entire debt is completely discharged. Then suppose, let us say, 4 people offer as sureties. Then in that case, if one obliger or one guarantor is relieved or is discharged, then in that case the guarantor who has given the guarantee can always question it. And then it is also said that care and caution, care and diligence has to be observed in all respects. Then sometimes it says reorganization, merger or consolidation of borrower with any other person. Sometimes what happens is there is a reorganization. Sometimes this company, which is the debtor, merges with another company, amalgamates with another company, or there is a restructuring of the capital structure as far as the debtor is concerned, or there is a merger, that is merger or consolidation of borrower with any other person. Suppose this company which has borrowed the money merges with another company and becomes one company, then in that case the question is surety till such time the amalgamated company discharges the debt, the guarantor is liable. Then please remember, as far as preference is concerned, no preference can be given to any, even in cases of any bankruptcy. Then 128 is liability coexistence. One of the most important cardinal principles of the law of guarantee is the liability of a surety is coextensive with that of the debtor. The guarantor cannot say Sir, please first proceed against the debtor, and in case he does not pay, then alone I will pay. No. The question is, as a lender, I can pick and choose between the principal debtor and the guarantor, and I can sue both of them and recover the entire money from the guarantor who has assured payment. Then the question is, anything done or any promise made for the benefit of the debtor is sufficient consideration for the surety. Please remember, the Contracts Act section 2D says every contract has to be supported by consideration, and any contract without consideration is a nullity, or it's a nudum pactum and cannot be enforced. Then, sir, what is the consideration for offering a surety, sir? The very fact that the guarantor has undertaken to pay the debt, perform the contractual obligations in case of default on the part of the principal debtor, and that too he has given it at the request of the principal debtor, that is sufficient consideration to sustain the guarantee. Then A requests to sell and deliver to him on credit, B agrees to do so, C gives guarantee for payment. This is sufficient consideration. Please remember, I think I referred to it in the previous class also. Suppose, let us say, a person at Rajamandri supplies goods to a person at Hyderabad, and let us say C says that you please deliver the goods. In case of non-payment on the part of the person who has received the goods, I will make the payment. That is itself sufficient to sustain the validity of the contract, and it is good consideration. And then the next illustration which is given is A sells and delivers goods to B, and afterwards requests A not to sue, and C will pay. This is sufficient consideration. Because please remember, if you read the definition of the word consideration in section 2D, it is said even forbearance, abstinence from suing. Suppose there is a contract between A and B, A delivers the goods and B is indebted to make the payment. Then C comes in and says, I will execute the guarantee, sir. In case B does not pay, I will pay the money. Here, the question is at the request of the lender, or as the request of the supplier, and at the request of the debtor. If a third person offers to perform the obligations, it is sufficient consideration. Then, of course, you know, under section 2D, any contract without consideration is void. It's a nudum pactum. It is unenforceable. But a contract of guarantee which assures payment in case of indebtedness, in case of non-payment, in case of non-fulfillment of the contractual obligations, it is sufficient consideration and cannot be said that it is without consideration. Then what are the essentials for guarantee, sir? One, there must be a debt, there must be a liability, and existence of debt and consideration is absolutely must, and it should be reduced in the form of agreement between the guarantor and the lender. Then the question of guarantee applies. Then we go to continuing guarantee. This is section 129, extends to series of transactions unless revoked for future transactions. Please remember, sometimes what happens is, once you go to the bank for a particular loan transaction, it is a continuing process. Not only that day, subsequently also you take loans, and subsequently also from time to time you obtain loans from the bank and to cover the limits. Then in that case, unless it is said that the guarantee is limited only to one transaction, it applies to all the transactions present, past and future, and such a guarantee is called a continuing guarantee. Then here the illustration given is, A agrees to be a surety for a contract between B, the creditor, and C, the debtor, for a particular transaction or a particular distinct series of transactions as per the contract. If C fails to pay for B for any of the contracts, A is liable to pay for it. A can either inform B and leave the contract for future transactions and or choose to remain as surety for future transactions. So a surety choice is taken whether he is going to offer as guarantor only for one transaction but also for future transactions. Unless his consent is taken, he is liable only for one transaction. Continuing guarantee means not only the past debts, present debts and future debts are transactions from time to time, and the guarantee agreement is not revoked or retracted. It continues till the future transactions are completely liquidated. Then revocation is 130 says as far as the future transactions are concerned. Here the guarantor may say under section 130, sir, my guarantee is only for the transaction dated 24/9/24. As far as future transactions are concerned, I am not responsible for it. In case he is made liable for the future transactions, he can always revoke it and say, I am only liable for the present transactions and not for the future transactions. Here, by death, the estate of the surety is liable. Here, since we say the liability of a surety is coextensive with that of the debtor, death does not defeat the debt. Once the surety remains, his Lrs will have to discharge the debt for and on behalf of the surety who is dead and gone. And then 133 says that subject without surety is liable for interest if here it is said change or variation without surety's assent. Surety is liable for interest of mention. Here the question is, suppose let us say there is a change and variation. Always the guarantor will have to be taken into confidence, and in case of any change that is made, any variation that is made without the consent of the guarantor is not bound. Then duration is, then the question arises, sir, till what time the guarantee survives? The guarantee survives for the period that is mentioned in the guarantee agreement. Then one of the classic examples I can give you of a guarantee is, that is, suppose let us say you are a member of a chit fund company, and let us say you have subscribed for a chit for 5 lakhs and that is payable within 5 years. That is, every month you pay a certain sum of money. Then every month the auction is held. At the auction, suppose let us say you are the lowest bidder and the chit is drawn in your favor. The question is, once the chit fund company wants to make the payment or you are entitled for payment, they will say you furnish 2 government securities, that is, people who are solvent persons, and those people stand surety. In case of non-payment, the sureties will be responsible. Then the question is rights of surety. One, subrogation. What do you mean by subrogation? That is, once the surety pays the entire amount, whatever is due and payable by the principal debtor, then the creditor's claim is completely satisfied. Whatever securities are had and received by the lender will have to be passed on to the subrogee, that is the person who is the surety, and that amount the surety has got the right of claiming it or asking for repayment of that money by the principal debtor, and this in law is what is called subrogation. Then indemnity. The question is, what do you mean by indemnity? Indemnity means whatever payments are made by the surety is entitled for being indemnified by the principal debtor for whose benefit he has paid the money. In other words, once the debt is completely satisfied, the surety steps into the shoes of the creditor and can bring an action to recover that money which he has paid for and on behalf of the principal debtor. Then he has also got a right of claiming back all the securities which are had and received by the lender at the time of sanction of the loan. Then right to securities, right to set off in case any amount is paid by the debtor, let us say by chance. Then that amount which is paid will have to be deducted from the liability of the surety. Then next one is judicial interpretation. Favorable position of the surety, liability, conditional payment towards liability, discharge due to variance, right of subrogation, request right to security. So once the debtor, the principal debtor, or the contractual obligations are performed, whatever securities are had and received by the lender automatically passes on to the surety, and the surety can recover that money from the principal debtor on whose behalf he has made the payment. Then sharing of liabilities among co-sureties. One, discharge of one surety discharges the other. Suppose there is more than one surety, one of them is discharged from the liability by the lender, and then the other sureties are not informed. Then the question is, they can say, sir, since you have discharged without our consent, we are also discharged from the liability. So, a discharge cannot take place without the consent of all the sureties. Then unless mentioned, all are liable. The question is, there is not any preference given to any surety, sir. If 4 sureties are taken, all the 4 sureties are liable. Then the next is A and B are sureties to C in a contract with E. E does not pay a debt of 1 lakh. Then A and B have to pay 50,000. Suppose let us say A and B are the sureties for C, and then let us say C and E is the creditor, and C does not pay. Then in that case, as far as the liability of the co-sureties are concerned, they have to contribute equally towards the debt. Then under what circumstances a discharge is done? Revocation, death of surety, then discharge by variance of debtor, variance or discharge of debtor, and except insolvency, promise not to sue. The question is, the surety gets discharged when the creditor himself says, don't bother Mr. Debtor, one more bakra is available, the guarantor is available, I'll recover the money from, for the present you need not pay. Then next one is, the debtor is discharged from his liability without the consent of the surety. Then in the next one is, suppose the contract is varied or modified without the consent or of the guarantor, then the guarantor is discharged from his liability. And its guarantee can be either orally or it can be reduced to writing. Here an example is given. A takes a loan from a bank. A promises to the bank to pay the loan. B also makes a promise to the bank that if A does not repay the loan, I will pay. Then in the event of A, the debtor is the debtor who undertakes to repay the debt, does not pay, the question of liability of the surety gets revived. Then, sir, if next we go to the same duty, there is the different the part of A, the bank. So the question is, if the choice is given to the bank to sue both the debtor as well as the guarantor, the question is, that's why we say, as far as the liability of a surety is concerned, it is coextensive with that of the debtor. The rest of it we shall continue in the next class, and because of some unforeseen circumstances, because of heavy rains here, we could not hold the class on these 2 classes. So we will have the continuation tomorrow.